Good evening, everyone. Welcome. Thank you all for coming. I'm Allison Caprone, the Executive Director of NYU's Program on Corporate Compliance and Enforcement. Before we get started tonight, just because so many of our PCC events in the past are off the record and they're not taped, I just want to make clear that tonight's event, we're operating under different rules. Tonight's event is on the record. The press is here. Mr. McDonald's speech will be recorded, and while the questions and answers after the speech will not be recorded, the press is still going to be in the room for the entirety of the event. Yeah, thanks. Thank you. So with that out of the way, it is my great pleasure to welcome James McDonald, the Director of Enforcement for the CFTC. Mr. McDonald joined the CFTC in April 2017 after serving as an Assistant U.S. Attorney in the SDNY, most recently in the Public Corruption Unit. Earlier in his career, Mr. McDonald served as a law clerk to Chief Justice Roberts on the United States Supreme Court, and before that as a law clerk to the Honorable Jeffrey Sutton Jr. on the U.S. Court of Appeals for the Sixth Circuit. A graduate of Harvard College and the University of Virginia School of Law, Mr. McDonald previously served in the Office of White House Counsel as a Deputy Associate Counsel and worked at the law firm of Williams and Connolly. He has also served as a visiting assistant professor in his hometown at the University of Tulsa College of Law, where he taught constitutional law, federal courts, foreign relations law, and Supreme Court decision-making. Please join me in welcoming Mr. McDonald. Thank you.
Thank you for that introduction. I'm happy to be back here at NYU today. Over the past few years, this program in particular, the program on corporate compliance and enforcement, has brought together some of the best thinking in enforcement, business, and the academic communities. And it's been a driver of some of the most significant developments in enforcement and compliance. We've followed these developments closely at the CFTC. At every stage of our agency's history, we've sought to bring impactful enforcement actions in the markets that we regulate and to ensure that we stand ready to meet the challenges presented by our ever-evolving markets. Our most recent challenge has included responding to the dramatic expansion of our jurisdiction under Dodd-Frank in the wake of the financial crisis. Under David Meister, who's here today, the first director of enforcement after Dodd-Frank, the division literally wrote the rules that set out some of our new enforcement jurisdiction. With the next director, Eitan Goldman, who's also here today, the division brought first-of-their-kind cases under these new rules. And under the leadership of both directors, we began to define our major priorities and to develop some of the initiatives that we rely on today, like the division's cooperation program. That's one of the things that I'll talk about today. Thanks to their hard work and that of the dedicated career civil servants that staff the division, we're well positioned today to build on those priorities and those initiatives. As part of this effort, we're consistently surveying the enforcement world to identify best practices and to incorporate them into our enforcement program. The work of the program on corporate compliance and enforcement here at NYU has been particularly helpful to us in that regard. In fact, it was a little more than a year ago that I was here in this same room with this same program, and we were talking about some of the priorities at the CFTC. We emphasized in particular the development of the division's cooperation and self-reporting program. But a lot's happened at the CFTC in the last year, so my plan tonight is to do three things. First, to give you an update on what we in the division have been up to over the last year. Our most recent fiscal year closed September 30th. Tonight, in connection with this speech, we're releasing an annual report of the division, which details our work over the last fiscal year. To save you the suspense, the report shows that by any measure, enforcement during the last fiscal year has been among the most vigorous in the history of the CFTC. The second thing I'll do tonight is I'll outline some of the major priorities and initiatives that have guided us over the last fiscal year. and that will guide us going forward. And finally, I'll offer an update about some recent developments in our cooperation and self-reporting program, which was the subject of my talk last year. So to start, I'll offer an overview of the last fiscal year. Before I begin, let me just take a step back and talk for just a minute about the way that we measure success in the division. Anytime we talk about year-end results, some of that discussion necessarily includes numbers. But a strong enforcement program is about more than just numbers. It's about preserving market integrity, protecting customers, and deterring misconduct before it happens. It's about being tough, to be sure, but it's also about being fair. And it's about allocating resources efficiently to ensure that our efforts target the most pernicious forms of misconduct in our markets. These sorts of things cannot be measured by numbers alone, and that's a good thing. Federal agencies shouldn't be motivated to hit certain numbers when enforcing the law. But at the same time, we recognize that numbers do tell part of the story. They might help show the direction an enforcement program is heading. They might reflect the types of cases that stand as priorities. Or they might offer some perspective on a program's broader goals. So in our annual report and this evening, we seek to offer some quantitative but also qualitative measures that tell the full story of our enforcement program. The annual report, which is available to all of you tonight, walks you through all these numbers, so I won't belabor them here, but I'll share with you the headline. This was a year of incredibly vigorous enforcement at the CFTC. That's true whether you measure it by the number of cases filed, by the amount of penalties imposed, by the number of large-scale matters, the types of cases charged, or the percentage of cases that include individual charges. For more details on these numbers, I refer you to the annual report, and I encourage you to read it. But what I'm going to do for the rest of the evening is take you behind the numbers, to walk you through how these numbers reflect our priorities and how we've begun or continued initiatives to advance these priorities. So let's start with the priorities. Our enforcement program over the last year largely centered around 4 priorities: preserving market integrity, protecting customers, promoting individual accountability, and enhancing coordination with other regulators and criminal authorities. Let's say a few words about each of those. First, preserving market integrity. When our markets are functioning well, producers are able to hedge the risk that this year's crop output might not be as good as the last, which protects them and consumers against unexpected price movements. And entities and individuals can allocate capital more efficiently, which contributes to the growth of the broader American economy. But these markets won't function well if participants don't have confidence in the integrity of the market. That's why at the division we've focused on detecting, investigating, and prosecuting misconduct that has the potential to undermine this integrity. Misconduct like manipulation, spoofing, and disruptive trading. The work of the division over the last fiscal year reflects this priority. During that fiscal year 2018, we brought more cases involving this type of misconduct than ever before. From 2009 to 2017, the CFTC, on average, brought about 6 of these cases each year. In the last fiscal year, we filed 26. Many of these cases required us to address particularly complex or novel patterns of manipulation, including those that cross markets, cross exchanges, even cross international borders. Others have required us to adapt to relatively new forms of manipulative conduct, like those that abuse technology or that seek to manipulate the structure of the electronic order book. But we've made acting against this type of misconduct a priority regardless of how complex or difficult. So the second priority I mentioned, protecting customers. Since its inception, the CFTC has focused on protecting customers in our markets from fraud or other forms of abuse. That focus remained a priority this last fiscal year, and it will remain a top priority going forward. The division aggressively prosecuted fraud in some of these traditional areas, like precious metals, forex, binary options. But this last fiscal year, we also saw fraudsters evolve as they sought to use new products or new technologies to target unsuspecting customers in markets like virtual currencies. We've worked hard to ensure that we're evolving with these bad actors and indeed staying one step ahead. We saw success in this area as well. In one of the largest binary options frauds ever charged by the CFTC, we charged a massive national and international binary options ring, which allegedly harmed approximately 75,000 victims. We charged numerous cases involving fraud in connection with virtual currencies. We charged one case that started out as a binary options fraud and then morphed into a virtual currency fraud during the lifetime of the scheme. And we've taken these cases to trial when necessary, winning significant trial victories during this past fiscal year, including a precedent-setting victory in a trial involving Bitcoin fraud here in the Eastern District of New York. So that's preserving market integrity and protecting customers. What about our effort to promote individual accountability? A consensus has now developed in the enforcement and business communities that individual accountability must sit at the center of any effective enforcement program. Some of this was developed right here at the PCCE, here at NYU. Just a few years ago that Deputy Attorney General Sally Yates released what's now known as the Yates Memo at a talk here as part of this program. We at the CFTC share in this consensus. It's not enough simply to hold responsible companies accountable, though that's part of it. The responsible individuals must be held accountable too. Individual accountability ensures that the person committing the illegal act is held responsible and punished. It deters others, fearful of facing individual punishment, from breaking the law in the future. It incentivizes companies to develop cultures of compliance and to report to regulators when they find bad actors in their entity. And it promotes the public's confidence that we are achieving justice. In pursuing individual accountability, we must look even beyond the employee who actually committed the wrongful act. We must also seek to hold accountable the supervisors and others in control who may be culpable as well. We prioritized individual accountability during this last year, with more than two-thirds of our cases involving charges against individuals. We charged individuals at financial institutions, proprietary trading firms, and managed funds. We charged primary wrongdoers and also those who facilitated or aided and abetted that misconduct. And we used all available theories of liability to help us reach up the chain, like supervisory and control person liability, which led to charges against supervisors, desk heads, CEOs, and a chairman of the board. Finally, during the last year, we prioritized coordination and enhancing our coordination with other regulators and criminal authorities. We can most effectively protect our markets when we're working closely with our colleagues in the enforcement and regulatory community, both domestic and international. That's particularly true as our markets evolve and as they become more interconnected. Bad actors, it turns out, don't conform their misconduct to the technical boundaries of different jurisdictions or to international borders. So regulators here in the United States and abroad have to work together to ensure that the misconduct is identified, is investigated, and prosecuted. This approach yielded results for us last year, as we investigated and filed a number of actions in parallel with our regulatory and enforcement counterparts, some of which are detailed in the annual report. Particularly noteworthy, I think, is our expanded effort to charge cases in parallel with our criminal law enforcement partners. During the last fiscal year, we filed more cases in parallel with our criminal counterparts than ever before. These include cases that range from spoofing to retail fraud, to virtual currency fraud, to manipulation of global benchmarks, to efforts to obstruct our CFTC's investigation. And that's just to name a few. This means that wrongdoers in our markets now face the reality not just of substantial fines, but also in appropriate cases of the prospect of criminal prosecution. This marks a trend that we expect to continue going forward, and we believe will significantly deter wrongdoers from committing misconduct in our markets going forward. So that's four major priorities that have guided our enforcement program going forward. How have we advanced them? We've advanced them by beginning or continuing several key initiatives during the last fiscal year. I'm going to talk about a few of them. The first is data analytics. Anyone in our markets knows that these markets are going through a revolution from analog to digital, from pit trading to electronic order books, from human trading to algorithmic, from standalone trading centers to interconnected trading webs. Emerging digital technologies are impacting trading markets in the entire financial landscape with far-ranging implications for capital formation and risk transfer. We've worked hard to keep pace with this technological change and to ensure we stand at the cutting edge of the data analytics world. We've primarily done this in three ways: by increasing the amount of data that's available to the division, by ensuring that we in the division have the tools necessary to assess, evaluate, and analyze this data, and by developing human capital in the division so that we can marshal this data to uncover and prosecute illegal conduct in our markets. Perhaps the most notable development in this area is the realignment within the Commission to move the Market Surveillance Unit into enforcement from the Division of Market Oversight where it previously sat. Another of our initiatives involves the creation of specialized task forces. During the last fiscal year, we expanded the foundation of our enforcement program into new areas where we saw or suspect misconduct. Areas like spoofing, virtual currency, and insider trading. Developing our program in these new areas, though, presented us with a new challenge. How do we move as quickly as required while ensuring that each of our teams across each of our offices approaches the matter in a smart and consistent way? Our answer was to develop a set of specialized task forces within the division. This is designed to ensure consistency, identify best practices, develop new approaches and ideas based on lessons learned. Each task force includes members from each of our offices in Chicago, Kansas City, New York, and Washington, D.C. And these task forces focus on four substantive areas. The first is spoofing and manipulative trading, or manipulative conduct. A little more than a decade ago, our markets moved from in-person trading to the pit, in-person trading in the pit to electronic trading in an electronic order book. The advent of the electronic order book brought with it significant benefits. It increased information available, reduced friction in trading, and significantly enhanced the price discovery process. But at the same time, that technological development has presented new opportunities for bad actors. Just as the electronic order book increases the information available to traders, it creates the possibility that false information injected into the order book could trick those traders to trade in a way that benefits the bad actor. The spoofing task force works to preserve the integrity of these markets from that type of misconduct. The second task force that we created relates to virtual currencies. The story of virtual currency is also about technology. And it's a story about the need for robust enforcement to ensure technological development isn't undermined by the few who might seek to capitalize on this development for unlawful gain. New and potentially market-enhancing technologies like virtual currency and the distributed ledger technology need breathing space to survive. And through the work of the CFTC, the agency has shown that it's committed to facilitating market-enhancing innovation in the fintech space. But part of that commitment includes acting aggressively to root out fraud and manipulation where we see it in these markets. The Virtual Currency Task Force is dedicated to identifying misconduct in these areas and to holding the bad actors accountable. The third task force focuses on insider trading and protection of confidential information. Illegal use of confidential information can significantly undermine market integrity and harm customers in our markets. This type of misconduct could include misappropriating confidential information, disclosing a client's trading position, front-running, or using confidential information to unlawfully prearrange trades. As we continue to build the foundation of our enforcement program, we'll continue to work to ensure that our market participants are not misappropriating client information or confidential information for their own benefit. Finally, the Bank Secrecy Act Task Force works to ensure that our registrants comply with their Bank Secrecy Act obligations and their anti-money laundering obligations. These include things like filing required suspicious activity reports and following the Know Your Customer program rules and other requirements that are associated with those programs. Each of these task forces, I expect, will play a significant role in our enforcement program going forward. So that's the priorities, those are the initiatives. There's one more thing I want to talk about tonight, and that's what I talked about last year, our cooperation and self-reporting program. And I want to talk to you about some recent developments in this area. Last year, we explained our view that this program would serve as a powerful tool to hold wrongdoers in our markets accountable. We explained that the program is designed to get companies and individuals who know about the misconduct to tell us about it, to enable us to identify all those involved in the wrongdoing, and to allow us to prosecute the most culpable individuals and companies. It's a tool that originated in organized crime and gang prosecutions and has been employed aggressively and with success in white-collar prosecutions as well. We've now incorporated this tool as part of our enforcement efforts at the CFTC. We're still just getting started, but the early returns look good. Through the end of the last fiscal year, we had issued 3 significant orders that involved self-reporting. Each included a civil monetary penalty that reflected a significant reduction on account of the self-report, cooperation, and remediation. We also employed our individual cooperation program to sign up individuals to cooperation agreements, which also led to significantly reduced penalties for those individuals, some of which even included no civil monetary penalty. When we announced the program, we made clear that it shouldn't be viewed as giving anybody a pass. That's been borne out over the last year. This past year, we filed cases against more financial institutions than all prior years but one. We brought charges against several individuals who work at those institutions. And through our cooperation and self-reporting program, we've been able to charge companies and individuals, including supervisors and senior management, that we otherwise might not have been able to charge but for our cooperation and self-reporting programs. What's more, this program is continuing to grow. We've just started the new fiscal year, yet already we've had 2 significant new developments. The first involved spoofing and manipulation charges against a defendant named Kamaldeep Gandhi, formerly a trader at several proprietary trading firms. As part of our investigation, Gandhi agreed to cooperate with the CFTC and entered into a cooperation agreement with the division. Under the terms of the agreement, Gandhi admitted to his own conduct and told the CFTC about others who were involved. Among other things, Gandhi's cooperation agreement binds him to continue to cooperate throughout the course of the CFTC's broader investigation. Because Gandhi's cooperation was not complete at the time of the resolution with the CFTC, the commission, bifurcated Gandhi's case. The commission decided liability in an order issued in October, but left the amount of penalty to be determined at a later date, once Gandhi's cooperation is complete. This bifurcation mirrors the criminal process, where the guilty plea comes first and the sentencing comes later, typically after cooperation is complete, at least in most jurisdictions. And Bifurcation allows the CFTC to consider the entire range of cooperation when it's determining his penalty. Gandhi's case stands as an example of the sorts of tools that we'll employ to ensure that we can use our cooperation program in the most effective way possible. That's the first time that we've bifurcated a case at the commission level on account of an individual's cooperation. But I expect that you'll see more of that in these types of cases going forward. The second major development on the cooperation and self-reporting front involved a case that we announced last week involving a former managing director at Deutsche Bank named Jacob Born. During the summer of 2017, Born mismarked the valuations of swaps in an attempt to cover up more than $10 million in trading losses. The mismarked swaps were then reported to counterparties and to the CFTC. Deutsche Bank's internal controls identified the discrepancies in Born's swap valuations, and having caught these discrepancies, the bank conducted an internal investigation, which determined that Born had mismarked the swaps in question and then altered documents to cover it up. The bank moved quickly to reach this conclusion. It identified the discrepancies less than a week after Born began mismarking the swaps, and it reached its conclusion that they were in fact mismarked less than a month later. 3 days after that, the bank self-reported Born's conduct to the Division of Enforcement of the CFTC. The bank then proactively cooperated with the CFTC and remediated to make sure the conduct didn't happen again. Born was placed on administrative leave and then ultimately terminated. The CFTC brought an action against Born for fraud arising out of his mismarking. But the division declined to prosecute the bank on account of its self-reporting, cooperation, and remediation. The declination letter is available on the CFTC's website. It includes more detail than I've just provided. I recommend that you read it. But stepping back just a bit, the takeaway here is this is how the self-reporting program is supposed to work. We want companies to have sufficient internal controls in place to catch wrongdoing when it happens. When they find misconduct, we want them to take appropriate remedial steps to fix the problem to make sure it won't happen again. And yes, we want them to tell us about it, and we want them to cooperate proactively in our investigation. If they do that, the individuals involved who are ultimately responsible can be prosecuted as Born was here. But the company will gain a substantial benefit as a result of its self-report, cooperation, and remediation. And in extraordinary cases, the company may receive a declination of prosecution altogether. Stepping back even further, though, this really goes to the heart of what we're trying to achieve with our enforcement program more generally. The end goal for us in enforcement, it extends well beyond the number of cases filed or the amount of penalties imposed. We intend for our enhanced emphasis on individual accountability, cooperation, and self-reporting, together with the other priorities I've discussed tonight, to have a far broader social impact. Our end goal is to foster a true culture of compliance among our market participants. When we talk about a culture of compliance, what do we mean? Think about it this way. Imagine a CEO standing in front of the company's new hires on their first day on the job. Imagine the CEO telling the new staff about the various trainings to come as part of the onboarding process, compliance, ethics, human resources, and the like. And imagine the CEO telling the new staff that notwithstanding these various internal company regimes, if they break the law, their problems won't stop with the compliance, ethics, or human resources department. Their problems will come from the CFTC and perhaps even the Department of Justice or the FBI. That's because, the CEO tells staff, the company is committed to identifying any misconduct and to reporting it to the relevant authorities when they find it. That's the sort of commitment we're trying to foster here. That's the sort of commitment that creates the culture of compliance that we want to see in our market participants. And that's the end goal for our enforcement actions. We believe this past fiscal year, particularly when viewed in light of the robust enforcement program we've built over the years, we think that shows that we've taken significant steps towards achieving this culture of compliance in our markets, and we'll work hard during the next fiscal year to help ensure that trend continues. Thank you.